All right.
Wait. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all.
Morning.
Give me one moment, please, to get up my screen. What should I have before me?
Justice Hennessy, I have an outline of the submissions, and I'd like to address that in just a moment, if I may begin. I have a few opening remarks I'd like to make.
Yes, when you are ready, please go ahead.
Thank you. My name is Glynis Evans, and I represent the Crown in Right of Canada, and I'm joined by my colleague, Ms. McNamara. As representatives of the Crown, we have had the privilege and the honor of attending with the court and the parties many Anishinaabe ceremonies in this case, including smudging ceremonies, sunrise ceremonies, pipe ceremonies, sweat lodges, and feasts. We have been deeply touched by the gracious hospitality shown by the Anishinaabe to all of the participants in this trial and in this proceeding. I have been told that the Anishinaabe are people of the land, and I have been told that the land is part of them, and they are part of the land. And since the Anishinaabe are part of the land, those of us who are relative newcomers to Canada, who live on the land and enjoy its beauty and its bounty, now are blessed to carry within us a part of the Anishinaabe. As a representative of the Crown in Right of Canada, I have the privilege of representing the people of Canada, which includes the Anishinaabe. Canada hopes that while this hearing is an adversarial process, this process may also be a reconciliatory one. I've handed out to my friends, and I'll hand out to you now, Your Honor, an outline of the submissions that I'll be making on behalf of the Crown and Right of Canada.
Excuse me. Oh, dear. Excuse me. I have to verify myself with my phone.
I'm sorry?
I'm sorry, I have to verify myself with my phone. We'll need a 5-minute break. Excuse me, I'm very sorry.
All right.
This court is stood down until recalled.
Okay.
No rights.
All right.
This court is resumed. Please be seated.
Best laid plans. I'm very sorry for that, Ms. Evans. Please go ahead.
Along that line of the best laid plans, your delay was quicker than mine will be. I realized that we delivered yesterday an electronic version of our compendium, but we do in fact have printed copies, and my colleague, Ms. McNamara, has just run back to our room to get the printed copies for those who like it in hard copy. So I will start by telling you what materials you should have before you. Canada will be referring to the record known as the revised record. You will have it in electronic format, and we will be referring to the tab numbers and page numbers from that record. We have also prepared a compendium, but the compendium only contains materials that are not already in the record. So you won't have to be flipping back and forth between which version. The record materials are all in the record. The compendium materials are things that aren't in the record. They're mostly things from the stage 3 trial. And my friend now has the hard copy of the compendium, which she'll hand up momentarily.
And will you ask that to be Exhibit E?
Yes, please.
Thank you very much.
While the compendium's being handed out, I'll just go through an outline of what I intend to cover, if I might. You'll see from the outline, the first issue I'm going to address is standard of review. Then the bulk of my submissions today are going to center on how Canada exercised its discretion. And you will see from my outline, there are a number of different topics that I'll be covering under that head. I will walk you through the development of Canada's position, which led to its exercise of discretion. I'll explain the relationship to the RHT settlement. Then I'll get into Canada's approach on what Mr. Schachter called the 3 big ticket items.
And I take it you agree that that's a name that's useful for you, or a reference, or no?
Actually, I don't really like the name 3 big ticket items, which is why I haven't used that terminology in my outline, but I just wanted to link that up with what Mr. Schachter said. I certainly do agree that those 3 issues, and 2 of them in particular, NCRR versus rents or a portion of them, and the bring forward rate, are responsible for the $30 billion gap between the parties. They are the drivers of the gap between the parties. I think maybe that's the way to put it, that I would prefer, as opposed to big ticket items, I would say the drivers of the gap between the parties.
Thank you.
It's my hope that I'll get through this item 2 on my outline today. I think it's going to take us quite a while to get through that in detail. And then I'm hoping that tomorrow I'll be able to address the next items, the RHT settlement, the process, ground allocation, costs, and orders sought. I think I can handle those in about an hour and a half, and that may have to bleed over into tomorrow. Now, just as a sneak peek, I'll tell you, on standard of review, I'm going to explain why in Canada's submission, this is a sui generis review, and the standard of review is deferential. That shouldn't be any surprise. It, of course, mirrors our factum. With respect to how Canada exercises discretion, as I noted, I'll take you through the evolution of Canada's positions and that ultimately led to its exercise of discretion. And I'll take you through Canada's approach to the drivers of the gap between the parties. When I do address the RHT settlement as a benchmark, I will explain how Canada determined compensation for the RST independently of the RHT settlement. And I will explain why the RHT settlement is indicative of honorableness and the honorableness of Canada's approach to the exercise of discretion. Then, in dealing with the issue of the engagement and negotiation process, my submissions will respond to the First Nations concerns that the process was not a true negotiation. I'll show you in the record that it was an honorable engagement and negotiation process, and it was a true negotiation. On Crown allocation, my submissions are: this court can decide the issue and should decide the issue, even though the decision will not affect the exercise of discretion for the past.
Or the exercise of discretion that is the subject of this review?
That's correct. It doesn't alter Canada's determination to pay $1.8 billion. Finally, on the issue, well, second to last, on the issue of costs, my submissions are that Canada's determination to pay $20 million in costs is honorable, and there is no need for another hearing to address costs up to January 27, 2025. Of course, costs of this review is a separate issue, but there's no need for this court to have another hearing to address costs up to January 27th. They have been dealt with by Canada's exercise of discretion, by Canada's determination to pay $20 million, matched, of course, by Ontario. And if there is to be another hearing on costs, it's not a hearing that the Crown would participate in. It's a hearing between the solicitor and his client, Mr. Schachter and White Sand Red Rock. And again, I'll flesh that out when we get to the cost issue. And finally, I'll address the order sought, which will include the contingent interest First Nations claim for an order providing for the post-judgment interest rate. So I'd like to begin on standard of review. I mentioned Canada's position is this is a sui generis review, but it is not significantly different from judicial review. The principles of judicial review apply because this is fundamentally a court's review of executive action, which is the bread and butter of judicial review. What makes this sui generis is that the Superior Court is not typically tasked with judicial review, and there is in fact authority to suggest that the federal court alone has jurisdiction to judicially review decisions of the federal crown. We're not going to worry about that here. We're going to accept that the Supreme Court ordered this court to conduct the review. We'll call it a sui generis review, but it is in fact, in effect, a judicial review. The standard of
When you say this court is not typically asked to conduct judicial reviews, you mean only with respect to the federal exercise of powers.
That's correct. The standard of review is deferential, which means it is not correctness. The Supreme Court explained in numerous paragraphs of its decision that deference is owed and that there can be a range of honorable results. That is simply not consistent with a correctness standard. A correctness standard means only one possible answer. And when describing the process required, the Supreme Court used language that echoes Vavilov, where the Supreme Court held that reasonableness is the default standard of review. The court also used language that echoes Hydonation, the Supreme Court's 2004 decision on duty to consult. There, the Supreme Court also held that reasonableness is the standard of review when the decision being reviewed is premised on an assessment of the facts or when the issue is one of mixed fact and law. And I will take you to both Vavilov and Hydonation. My friends argued that there's some kind of distinction between decisions of administrative tribunals and executive decisions of the Crown, and that this review is different because it is a review for constitutional compliance. But I will show you through the case law that there is no such difference in the law between judicial reviews of decisions of administrative tribunals and decisions of ministers of the Crown. Vavilov tells us that. And courts routinely judicially review executive conduct for constitutional compliance. And I will take you to a few examples of that. They are also noted in our factum. All parties agree that matters of law, including the applicability of the charter, for example, or the duty to consult, or the nature of the constitutional right, are matters to be determined on a standard of correctness. Everything else is reviewed on the deferential standard of reasonableness. My friends are attempting to squeeze into the standard of correctness questions that they characterize as constitutional, which do not in fact require a correctness review. This reminds me of what I call the olden days of administrative law, when parties and courts had to grapple with this idea of jurisdiction. What is or isn't an issue of jurisdiction? Does it go to the vires? And parties had a hard time putting into categories or attempting to characterize their issue as one of jurisdiction in order to attract the correctness review. But the Supreme Court got away from that, that kind of paradigm. And similarly, I think the court needs to keep in mind here that let's look at the issue in its context to properly determine whether it really is one of law that requires a correctness determination or one of fact or mixed fact in law that requires the deferential standard. Fortunately, though, Justice Hennessy, I agree with my friend, Mr. McIver, who told you, you don't really need to get into these fine points of administrative law. All you really need to do is look at what the Supreme Court told you to do in Restool. But of course, where I differ with Mr. McIver is I'm going to show you parts of the decision where the Supreme Court makes it clear that it expects this court to exercise a deferential standard of review. And that's where we'll start. There are 4 issues that I want to deal with as part of standard of review. The first one is I'll go through parts of the Supreme Court's decision that tell you that you must approach the Crown's decision with deference. Then I'll take you to the cases of Haida Nation and Vavilov, as I said I would. Then I will provide you briefly with a few examples of cases where the court has judicially reviewed government decisions on the standard of reasonableness, even where they involve constitutional issues. And finally, I'll comment on a couple of the cases that my friends cited, where I'll explain why their interpretation of them was incorrect. So I want to start with parts of the decision that tell you to approach the Crown's decision with deference.
Let me just put the decision before me. Thank you.
The first one I'm going to refer to, we've already visited a few times during this hearing, Justice Hennessy. It's paragraph 294, and I'll have my colleague put it up on the screen. One of the issues we've discussed in reviewing this passage of the Supreme Court's decision is whether it addresses the procedure for the past or the procedure for the future. I agree with my friends that in the beginning of the paragraph, it's talking about how the Crown should exercise its discretion in the future. And then it says determining the amount for the past will involve similar considerations. But where I want to start is where the highlighting, and I hope you can see that at paragraph 294, it starts maybe about a third of the way through the paragraph. The amount by which the Crown might increase the annuity is a polycentric and discretionary determination that will inevitably reflect many social, economic, and policy considerations that may change over time, affecting the frequency and nature of net revenue and annuity calculations. Determining the amount of compensation owed for the past will involve similar considerations. I stress that courts are not incompetent or unable to entertain these considerations when necessary. Indeed, I acknowledge the jurisdiction of the courts to order compensation at stage 3, if appropriate to do so. However, I also recognize that courts are generally not well equipped to make polycentric choices or to evaluate the wide-ranging consequences that flow from policy implementation. Accordingly, courts should exercise considerable caution before intervening in such circumstances. The next paragraph, and I only have 3 of them that I'm going to draw you to, is paragraph 299. And that starts, the part of the passage I'm particularly want to draw to your attention is maybe about 5 lines down, 4 lines down. It is appropriate in this case for this court to order the government to repair the breach of its constitutional obligations while leaving it up to the executive branch to determine the best means of doing so. And finally, paragraph 308. And here, we've been through this paragraph before, but I am going to just start, in the interest of time, at the second paragraph. A reviewing court should allow the Crown, as decision maker, a degree of deference in relation to its exercise of discretion. assessing the Crown's determination, the court must consider the Crown's submissions on how it reached its determination and why, bearing in mind the Crown's expertise in making complex polycentric decisions and recognizing that the exercise of discretion may permit a range of honorable results. The court should focus on the justification of the Crown's determination, having regard to the honor of the Crown. Now, I wanted to take you to Haida Nation and to Vavilov, and we'll do that in that order because, of course, Haida Nation was first in 2004. Haida Nation was a case involving duty to consult. The government had issued timber licenses on lands that were subject to an Aboriginal title claim from the Haida Nation. And the Supreme Court explained the duty to consult and then noted, if the Crown is challenged on the basis of allegations that it failed to discharge the duty to consult and accommodate, what is the standard of review? And here I want to take you to paragraphs 60 and 61. The Supreme Court says, where the government's conduct is challenged on the basis of allegations that it failed to discharge its duty to consult and accommodate pending claims resolution, the matter may go to the courts for review. To date, the province has established no process for this purpose. The question of what standard of review the court should apply in judging the adequacy of the government's efforts cannot be answered in the absence of such a process. General principles of administrative law, however, suggest the following. And Canada cited this case in its factum for the proposition that principles of administrative law also apply here if this is viewed as a sui generis review. But in paragraph 61, the Supreme Court goes on to say, on questions of law, decision maker must generally be correct. All of the parties agree with that. On questions of fact or mixed fact and law, on the other hand, thank you, Ms. McNamara. On questions of law or mixed fact and law, on the other hand, a reviewing body may owe a degree of deference to the decision maker. The existence or extent of the duty to consult or accommodate is a legal question in the sense that it defines a legal duty. However, it is typically premised on an assessment of the facts. It follows that a degree of deference to the findings of fact of the initial adjudicator may be appropriate. The need for deference and its degree will depend on the nature of the question the tribunal was addressing and the extent to which the facts were within the expertise of the tribunal. I'll omit the cites. Absent error on legal issues, the tribunal may be in a better position to evaluate the issue than the reviewing court, and some degree of deference may be required. In such a case, the standard of review is likely to be reasonableness. To the extent that the issue is one of pure law and can be isolated from the issues of fact, the standard is correctness. However, where the two are inextricably entwined, the standard will likely be reasonableness. Now, I draw this case to your attention, Justice Hennessy, for a few reasons. One of them is that the Supreme Court uses the language of a degree of deference
In Restool
in Haida Nation
or in high.
and in Restool. So I'd suggest that Haida Nation provides some assistance for us in understanding what the Supreme Court meant by a degree of deference, because they use that terminology in Restool as well. So there's different ways to look at this, Justice Hennessy. Of course, on the one hand, a degree of deference could be interpreted as some deference, anything that would be the alternative would be complete deference, which wouldn't even be concerned with issues such as transparency, intelligibility, justification, or rational connection to law and fact. That would be complete deference. And obviously, nobody's suggesting here that the court owes complete deference to the Crown's decision. So in that case, a degree of deference is a way to express that deference, of course, must be accorded in consistent with the law, as Vavilov tells us, and we'll get to. There still has to be a rational chain of analysis and a connection to the law and the facts. So that is how you can view what degree of deference means. My friends seem to suggest that degree of deference carries with it an idea that there may be gradations of deference. And I would respond to that, Justice Hennessy, by saying gradations of deference is what the Supreme Court deliberately moved away from in its Dunsmuir decision, which was 2008, when it got rid of this range of reasonableness. We used to have patent unreasonableness and reasonableness simpliciter. The court in Dunsmuir and then emphasized in Vavilov, the default standard is just reasonableness. So that brings me to the question of.
So let me see if I understand this. You say a degree of deference is not to be understood necessarily in the ordinary use of a degree, but rather understood as a term that became defined in Haida Nation, and that it is the opposite of a reasonableness standard, or sorry, a correctness standard.
That's
the opposite
correct,
of it.
Justice Hennessy.
That it is one or the other.
Yes.
As someone described it in their materials, possibly Ms. Boyce Parker, when she said it's not a binary question, you say it is a binary question.
It is a binary question, correctness or a deferential standard. And the deferential standard is reasonableness. Whether you describe that as a degree of deference or just deference, it's a binary in the sense that it is not correctness. And the next thing I want to get into is, how does reasonableness relate to honorableness? Because I think that's part of the question as well. My understanding of my friend's submissions is that, and I could be mistaken, but my understanding of their submission is that here, first of all, because it's an issue involving a constitutional question, but also given the honor of the Crown, that a different standard applies here. It's some higher level of reasonableness. It's this honorableness. It's something higher, and that's why the court only owes a degree of deference, not much deference, just a degree. That's what I'm understanding my friends to be suggesting. And what I'm telling you, Justice Hennessy, is deference is deference. It's the opposite of correctness. It's where there is fact or mixed fact in law that needs to be assessed, when there's a range of possible acceptable results, when it's an issue that the decision maker has some area of expertise. These are all the deferential standard, whether you describe it as a degree of deference, whether you describe it, and I'll get into this, as honorableness as opposed to reasonableness, it's all in the deferential standard side of this binary. So I wanted to address in particular honorableness and reasonableness, because in Restool, the Supreme Court doesn't come out and say the standard of review will be reasonableness. The Supreme Court instead uses the word honorable. The court is to review whether the Crown has exercised its discretion liberally, justly, and honorably. Here I'm looking at paragraph 308, which we've been to already. And of course, the court says the amount of compensation the Crown determines to pay must be honorable. You see that in paragraph 304 as well. It's not surprising that the Supreme Court used the language of honorableness, because it is consistent with the language of the principle of the honor of the Crown. But I submit But honorableness and reasonableness mean the same thing in the context of this review. And there are a few reasons why. Both are deferential standards. Both admit of a range of acceptable outcomes. And I refer you again to that range of honorable results, Supreme Court noted. Again, I make the point that, as I mentioned earlier, the Supreme Court abandoned this idea of gradations of reasonableness by abandoning that old regime where we had patent unreasonableness, reasonableness, simpliciter. The concept of reasonableness as a grade, the concept of honorableness as a grade of reasonableness doesn't sit well with that Dunsmuir framework. And I also want to take you to a case which you may find helpful. It's the Manitoba Métis case, 2021, a decision of the Manitoba Court of Appeal. We cite this case in our factum as one of the examples where, even though a constitutional issue, which in that case was the applicability of the duty to consult, even though a constitutional issue was at play, the standard of review was reasonableness in that case. But here I want to cite it for paragraph 3, where it kind of talks about this interplay between honorable and reasonable. For the reasons that follow, I agree with the MMF, Manitoba Métis Federation, that the judge who heard the judicial review application, the reviewing judge, erred in deciding that the honor of the Crown had no application in this case. However, while the honor of the Crown was engaged, I'm satisfied that, in the circumstances, Manitoba acted reasonably as to its obligation to act honorably. I don't know whether or not you'll find that helpful, Justice Hennessy. I submit that this idea of the Crown acting reasonably as to its obligation to act honorably indicates that there's a link between those concepts. And that's because, obviously, only an honorable exercise of discretion would be reasonable. It would be reasonable in a case where the honor of the Crown applies, as it did in Manitoba Métis and as it does in our case.
Only an honorable exercise of discretion would be reasonable or would meet the reasonableness test. Is that what you're saying?
That's right.
And do you say, therefore, that you couldn't make that sentence and say it would be correct? Only an honorable exercise of discretion would be the correct exercise of discretion. That sentence doesn't work?
No, I don't believe that it does, Justice Hennessy. I do think you can say a correct decision would be honorable.
Okay.
I don't think you can say the reverse, that an honorable decision there can only be one correct decision that is honorable, because the Supreme Court tells us point blank, there can be a range of honorable results.
Mm-hmm. And you say, as soon as you see the word range, you move to a reasonableness standard.
Yes, and I should note, I do have some discomfort with the language of a reasonableness standard, because, as I said, number one, the court doesn't actually use reasonableness in its decision. Number two, Canada acknowledges here and acknowledged in its factum that it is bound by the honor of the Crown. The standard of review here is deferential. We haven't called it reasonableness in our materials. We've called it deferential. But what I'm telling you is, when you look at the case law, the deferential standard is equivalent to the reasonableness standard. It's not correctness. Now, this may be a fine point. I think my friends from Ontario will tell you it's pure and simple reasonableness. And I'm not putting words in their mouth, but from having read their factum, I think that is a way you can look at it. That really stripped down what this is a reasonableness standard. And I think Haida Nation leads us in that direction. when the Supreme Court said in Haida Nation that these issues about not just is the duty to consult engaged, but rather the question that is premised on the assessment of the facts is assessed on, Haida Nation says, a reasonableness standard. So I do think reasonableness is one way you can look at it. What I'm telling you is it doesn't really matter whether you call it reasonableness or honorableness. The fact is it's a deferential standard of review.
So although you don't want to engage or begin a discussion of gradations of reasonableness, you stay away from the word reasonableness and say it's a different standard. It's deferential.
I think
I don't want to, it's not that it's a quarrel, but I'm just trying to make sure I understand where you are.
Yes. And I think, Justice Hennessy, I would liken it to why I just don't feel comfortable with the idea of big ticket items. I talk about them as drivers of the gap. It's a matter of respectful language, I think. But when you take a look at the legal principles, a deferential standard is a reasonableness standard. And I'm telling you that the Crown's position, Canada's position is, it's a deferential standard here. Whether you call it honorableness or reasonableness, it fits within the case law on reasonableness because it's a deferential standard.
So if it fits within the reasonableness case law and therefore the reasonableness tests, but you say it's deferential, do you say that is part of the sui generis review that's going on here? That one of the things is we'll have to call the standard in this sui generis review a standard of deference?
Yes, that is
That way you-
Canada's, that is
Yep.
Canada's position. That's why we've used in our factum the language of this is a sui generis review. The standard of review is deferential. It's deference.
And with my last question on this, and is that because you trip over the word reasonableness when you look at what the court has to assess vis-a-vis an exercise that attracts the duty of honor of the Crown?
Justice Hennessy, I think this is an area where people can disagree on the language, but I can say that the Crown and Right of Canada agrees on the implication, which is that it's a deferential standard. There is, and I'm going to show you, and I have showed you in Haida Nation, a reasonableness standard in this case is going to be, there is a link between honorableness and reasonableness because only in the circumstances of this case, only an honorable result will be reasonable. So there is that link between the two. It is true that I've hesitated to use the language reasonableness as boldly as Ontario does, primarily because the Supreme Court doesn't actually use that language itself. And just to be true to what the Supreme Court has told us to do in Restool, I'm using the language of honorableness because that's the language the Supreme Court used. But what I'm saying is by using that language and the way that it was used, the Supreme Court is telling us what they're really referring to is the reasonableness approach. And my friends, Ontario, in their factum had an excellent chart, which I imagine they'll take you to. You may remember seeing it, where here's the language that the Supreme Court uses in Restool. Here's the language that they use in Vavilov. You see what the Supreme Court was saying is it's the reasonableness standard. Now, they didn't use the word reasonableness.
For some reason, they didn't use it.
That's right. And so what I'm saying on behalf of the Crown and Right in Canada is we will accept, this is a sui generis review. First of all, it's going before a Superior Court judge. Secondly, Supreme Court doesn't use the word reasonableness, it uses the word honorableness. But what I'm telling you, Justice Hennessy, is it also drops a whole lot of breadcrumbs to lead us to the conclusion that what they're looking at is a deferential standard. It fits squarely within what they're talking about in Haida Nation and in Vavilov. So I want to now look at Vavilov, because if we talk about, whether we talk about it as reasonableness or honorableness, and I say honorableness is the same as reasonableness in this context. Honorableness is the same as reasonableness in this context, in this case, because they are both deferential standards of review. The Supreme Court has told us to follow, use the same kind of language that it used in Haida Nation and Vavilov. We're talking about a reasonableness review. And so what does reasonableness mean? And that's where I want to turn to Vavilov, because Vavilov explains what reasonableness actually means. And so here I want to put up, we'll start at paragraph 85. Reasonableness, before I get to the specific quote, I'll summarize Justice Hennessy this way. Reasonableness is concerned with the existence of justification, transparency, and intelligibility. Vavilov expresses this as an internally coherent and rational chain of analysis. So here, to find the Crown's decision honorable, you need to find an internally coherent and rational chain of analysis, and the decision must fall within a range of outcomes which are defensible in respect of the facts and the law. Vavilov expresses this as justified in relation to the facts and law that constrain the decision maker. This isn't a two-part test, but it is because the ultimate test is whether the decision falls within a range of reasonable outcomes. It's not a two-part test, but there's two sort of aspects to it. You need the rational chain of analysis, and it needs to fit within or be defensible in respect of the facts and law. So there's just a couple of paragraphs of Vavilov that I think make this clear that I like to go through. The first is paragraph 85. And it just reiterates what I've said, Justice Hennessy. Developing an understanding of the reasoning that led to the administrative decision enables a reviewing court to assess whether the decision as a whole is reasonable. As we will explain in greater detail below, a reasonable decision is one that is based on an internally coherent and rational chain of analysis, and that is justified in relation to the facts and law that constrain the decision maker. The reasonableness standard requires that a reviewing court defer to such a decision. And then in paragraph 86, starting at the highlighted section about a sentence down, reasonableness, according to Dunsmuir, is concerned mostly with the existence of justification, transparency, and intelligibility within the decision-making process, as well as with whether the decision falls within a range of possible acceptable outcomes, which are defensible in respect of the facts and law. And Justice Hennessy, when I take you through Canada's exercise of discretion, I intend to show you Canada's decision-making was rational. It followed a coherent and rational chain of analysis, and it is defensible within the range of outcomes that is permissible in respect of the facts and the law. Now, while we're on Vavilov, I also wanted to bring up paragraph 88 and 89, because these paragraphs, Justice Hennessy, address my friend's suggestion to you that there's some sort of different type of judicial review or different type of standard applicable when we're talking about decisions of executive decision makers as opposed to administrative tribunals. And I'm telling you that that is not the case. In the law, it is the same standard of review analysis. And here we see this in paragraph 88 of Vavilov. In any attempt to develop a coherent and unified approach to judicial review, the sheer variety of decisions and decision makers that such an approach must account for poses an inescapable challenge. The administrative decision makers whose decisions may be subject to judicial review include specialized tribunals exercising adjudicative functions, independent regulatory bodies, ministers, frontline decision makers, and more. Their decisions vary in complexity and importance, ranging from the routine to the life-altering. These include matters of high policy on the one hand and pure law on the other. Such decisions will sometimes involve complex technical considerations. At other times, common sense and ordinary logic will suffice. Paragraph 89, despite this diversity, reasonableness remains a single standard, and elements of a decision's context do not modulate the standard or the degree of scrutiny by the reviewing court. This, I submit, is strong language. The Supreme Court is telling us reasonableness is the deferential standard. You might call it honorableness in the context of this specific case, but it is the reasonableness standard in that it's deferential, it admits of a range of results, and it's not correctness.
Thank you.
I just wanted to go to a couple of cases. They're noted in our factum. I don't know how much detail we need to go into them, but I'll mention them. Cases where the courts have judicially reviewed government decisions on constitutional issues on the reasonableness standard. And of course, Haida was the first case. Haida was relied on in a case referred to by my friend, Ms. Boyce-Parka. It's spelled K-T-U-N-A-X-A. I understand it's pronounced, or can be pronounced, Tunaha. So that was a decision of the Supreme Court in 2017. It follows on Haida. This was a decision on involving the ski hill. The Tunaha Nation had brought a claim. My friend characterized it as though it was just a statutory decision. But in fact, the Tunaha had brought a claim on the basis of freedom of religion. They wanted to stop the ski hill development on the basis of freedom of religion and also duty to consult. So this case really did engage constitutional principles. And at paragraph 77, the Supreme Court said, the minister's decision that an adequate consultation and accommodation process occurred is entitled to deference, and cites Haida. The Chamber's judge was required to determine whether the minister reasonably concluded that the Crown's obligation to consult and accommodate had been met. And here's the point that I want to drive home, Justice Hennessy. A reviewing judge does not decide the constitutional issues raised in isolation on a standard of correctness, but asks whether the decision of the minister on the whole was reasonable. I think this goes to the issue that I mentioned earlier, Justice Hennessy, about yes, all the parties agree there are certain types of questions that require a correctness standard because they're issues of law. Does the duty to consult apply in this circumstance, for example? Or does the charter apply in this circumstance, for example? We'll get to. But in terms of how the charter right is accommodated or how the constitutional right is addressed by the Crown or the decision maker is an issue of fact or mixed fact in law and assessed on a reasonableness standard.
May I ask whether in Haida or in Tunaha was the decision of the minister an exercise of discretion? The decision to grant the license?
I'm going to have to get back to you on that. Let me get back to you on the specific wording. I'm imagining what you're getting at is a discretionary decision as opposed to one that was
Decision based on statute.
on a statute.
Or something, I don't know, but I believe there is no debate that the treaty provided the Crown with discretion on at least on the amount of the annuity or the augmentation. So that was a discretionary decision in the hands of the Crown. And this review is whether the Crown in this case that you have just, in this situation which you have just gone through, whether that exercise of discretion attracts or how much discretion it attracts. And you tell me that reviewing courts looking at decisions of ministers in these two cases were subject, that their decisions were subject to a reasonableness standard. Are they in the same character of decision?
Well, it still requires discretion on the part of the minister to, whether there is a duty to consult is the legal question. But once there's a finding there is a duty to consult, it's actually discretionary on the part of the minister in terms of how that duty is going to be met. And the court reviews the minister's discretionary decision on how it's going to be met on a reasonableness standard. It's not a binary choice. The minister can say, okay, no, we know we have a duty to consult, therefore we have to do X or we have to do Y. The whole concept of duty to consult is it's a range that varies with the circumstances. So the minister's decision as to how the minister is going to implement that duty to consult is a discretionary one.
How they do it, but not if they do it.
That's correct.
You say that matches what the Crown is required to do here?
Yes, it does. Yes, it does. In the way we express it in our factum, the treaty interpretation is what requires the correctness standard, and the Supreme Court has interpreted the treaty. Now, how the Crown implements that is an issue of discretion. And let me take you to paragraph 180 of the Supreme Court's decision. Because this came up in a couple of times in my friend's submission. Let's look at paragraph 180 of the Supreme Court's decision. Just waiting for my friend to, my colleague to get it up on the screen for us. So this is where we talk about the form, level, and aim of the sharing. So let's start at the beginning of the paragraph because it's an important one. Even accepting, however, a general concept of revenue sharing, as did the majority and minority of the Court of Appeal, this does not resolve whether the Robinson Treaties provided for an annuity with both collective and individual parts, or whether the augmentation was obligatory or discretionary. It also does not clarify what form the, quote, sharing should take. As the Court of Appeal majority stated, quote, the parties in negotiations or the trial judge in stage 3 must determine the form, level, and aim of the sharing that the augmentation clause requires. They added that this exercise should be led by the treaty parties, shared goals, expectations, and understandings in 1850, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal, identified by the trial judge, and the Crown's commitment to being both liberal and just. This is the task of reconciliation. This is important. I agree with these observations, subject to the discussion below regarding the appropriate remedy. And here, remember, the Supreme Court is quoting from the majority of the Court of Appeal, which was effectively overturned. The majority decision was overturned, and saying that the Court of Appeal said the form, level, and aim of the sharing is to be determined by the parties in negotiations or the judge in stage 3. But the court goes on to say, I agree with these observations subject to the discussion below. And in the discussion below, paragraph 181, the court says at the very last sentence, which is highlighted above, as I explained below, the quote sharing, and notice the Supreme Court's using the same quotes they did in paragraph 180. What is meant by sharing? They're getting at. Here they're saying the quote sharing is to be effected by an exercise of Crown discretion that reflects the honor of the Crown and abides by the Crown's promise to the Anishinaabe to deal liberally and justly with all her subjects, having regard to the relative wealth and needs of all the Crown's subjects, signatories and non-signatories alike. So here's an issue where The Supreme Court has interpreted the treaty so as to require the Crown to engage in a process of determining, working with the First Nations, ideally, to determine the form, level, and aim of sharing. But ultimately, the Supreme Court determines that the sharing is to be effected by an exercise of Crown discretion. And that, Justice Hennessy, is consistent with the language of the treaty itself. As Her Majesty may be graciously pleased to order. And the Supreme Court's finding that the Anishinaabe understood that concept. So I come to that point because I'm trying to answer your question about which parts are discretionary decisions. And I'm saying the Supreme Court has provided guidance on, and in fact, this court did at stage 1, on what that augmentation clause means. That's an issue of correctness. What does it mean? Well, here we know it means that the Crown has a duty to exercise its discretion. This was different, of course, from the original stage 1 trial decision was that there was a mandatory obligation to increase the annuity without limit. And the Supreme Court has told us now the obligation is to exercise discretion. It's a discretionary decision of the Crown. And I submit the Supreme Court makes that clear in paragraph 181. The sharing is to be effected by an exercise of Crown discretion. If I might, Justice Hennessy, there was one other case I wanted to refer to that I think is helpful, where courts have judicially reviewed government decisions on constitutional issues on a reasonableness standard. And it's the Manitoba Métis case from the Manitoba Court of Appeal of 2021. And I'd like to pull that up because I think it's got a few good pithy quotes, I think, that will be helpful here. And they start with, they start at paragraph 16. So the Manitoba Métis case involved, the Manitoba Métis had reached an agreement with Manitoba Hydro. The Manitoba government effectively canceled a part of that contract, rescinded a term sheet, I think is the way that the case puts it. And the first issue was, does this engage the honor of the Crown? Does this fact scenario even engage the honor of the Crown? And paragraph 16 says, the first issue is whether the honor of the Crown was engaged. By which standard is a reviewing judge to review this issue? The short answer is that, given the constitutional nature of the question, the correctness standard of review applies. Everybody would agree, I think. But then the court goes on to say that the review is comprised of several steps, and it is a multifaceted standard of review. So the court goes on to explain in these enumerated paragraphs, paragraph A, on constitutional matters, there can only be one correct answer. Reasonable people cannot disagree on the answer. That's what correctness is. Reasonable people cannot disagree. Then I look at subparagraph C. Certain duties, i.e. duty to consult and accommodate, flow from the principle of the honor of the Crown, to the extent that the manner in which these duties are carried out is premised on an assessment of the facts. The adequacy of how they are discharged is owed deference and will generally be reviewed on the reasonableness standard. And here they cite the Haida Nation case that I took you to. That's where the quoted portion comes from, premised on an assessment of the facts. And I'll show you, of course, Justice Hennessy, when we go through Canada's exercise of discretion in this case, it's entirely based on the facts. And then I think I was reading from paragraph C. Paragraph D has similar language. Certain obligations, i.e. to act honorably, with integrity and in good faith, also flow from the principle of the honor of the Crown. That's the one that really fits in with our situation here. It's not the duty to consult, but the duty to act honorably. also flows from the principle of the honor of the crown. Once again, to the extent that the manner in which they are carried out is premised on an assessment of the facts, the adequacy of how they are discharged is generally reviewed on the reasonableness standard. And this, I submit, is helpful for our case. This is what the Manitoba Court of Appeal is addressing here, is even when you're looking at obligations that flow from the principle of the honor of the crown, the manner in which those obligations are carried out and the adequacy of how they're discharged is reviewed on the reasonableness standard. The next paragraph that I have highlighted here goes to the issue of onus, where the reasonableness standard applies. The party challenging the decision has the burden to show that it is unreasonable. We've noted in our factum why it's Canada's position that the onus in this case is on the First Nations. I just wanted to confirm that this decision of the Manitoba Court of Appeal, leave to appeal to the Supreme Court, was dismissed. There's another case that we note in our factum. I don't think we need to turn it up. It's a Queen's Bench decision of the Alberta Court, Alberta Queen's Bench, the Métis Nation Association, which just follows along this, along the reasoning, and actually cites from this Manitoba Métis case for the same point, that if the honor of the crown was engaged, the standard of reasonableness applies in assessing Alberta's conduct in the circumstances. That's cited in our factum. It's Métis Nation Association, 2022 of the Alberta Queen's Bench at paragraph 165. This was also upheld on appeal, and an application for leave to the Supreme Court was dismissed. Just not going to turn it up because it just follows on the heels of the Manitoba Métis case. It's the same kind of issue. In paragraph 26 of our factum, we go through a couple of other examples of other contexts in which the court uses a reasonableness standard, even where constitutional protections, such as charter protections, are an issue. And this is, we've talked about in the Aboriginal context, in the duty to consult kind of context, but it's the same case in other situations, such as charter cases. The examples that we provide in our factum is extradition, for example. That's the Lake case of the Supreme Court, where
Sorry, what's the name of the case?
Lake.
Lake. Got it.
Lake.
Thank you.
Mr. Lake was a dual Canadian-American citizen, and the minister determined to extradite him. And he made a claim for judicial review of that determination on the basis of his Charter Section 6 mobility and Section 7 life liberty protections. And the Supreme Court determined that I should bring my factum back up. The issue was determined on a reasonableness standard, whether the minister's decision was reasonable, because the minister had expertise on the different issues that were at play, including Canada's relationship with international reputation and relationship with the foreign government. So there's a balancing required. So that was a case cited because it deals with constitutional issues, charter issues, and the Supreme Court held that the appropriate standard of review was reasonableness. Another example is the Doré case, which was a 2012 decision of the Supreme Court. This was the case, my friends have referred to it as well. It involved a spat between a lawyer and a judge, and a letter writing campaign. The lawyer was reprimanded by the Law Society, the Quebec Law Society, and then challenged that reprimand So it was a decision of an administrative tribunal, effectively being the Law Society. The lawyer challenged the reprimand. Now, to be precise, there was two components to it. There was a reprimand. There was also some limitation on his practice. I can't recall exactly what the facts are, but the relevant point is the issue at stake, the constitutional issue at stake was freedom of expression. And the Supreme Court noted that it determined that the standard really is a reasonableness standard when the court is reviewing how a decision maker accommodates or responds to or balances the charter right. There's different factors at play that the decision maker, in this case, the Law Society, had to determine. For example, the reputation of the legal profession, administration of justice, and those kinds of things. And those were reasonable things to be considered by the Law Society, and therefore the analysis of the charter right was subject to the reasonableness standard. I don't know if I'm articulating that well enough. This gets me.
But you wouldn't say that, for instance, in that case, the decision maker has an interest, the same kind of interest as an interest in determining the quantum of the augmentation or the compensation for past annuities.
The facts are completely different. And obviously I recognize the solemnity of this particular case before you and the fact that it implicates the honor of the crown, but fundamentally I don't see a difference.
The difference I'm talking about is the interest that the decision maker has, the if I could call it the personal interest. The decision in this case concerns the pocketbook or the bank account of the decision maker. The entity that has to make decisions about what money is spent from the crown.
Actually, Justice Hennessy, I would say I'll approach it from both perspectives, from two sides, because when you take a look at the decision before the crown in exercising its discretion, it's not just a matter of the pocketbook. It's not just a matter of how much money. It's a matter of how do you balance this with the wider needs of Indigenous and non-Indigenous Canadians. It's not just an issue of money. It's also an issue of reconciliation, which isn't just an issue of money.
But when one talks about balancing the interests of others, Indigenous and non-Indigenous Canadians, isn't the crown looking at money?
Well, I think about it this way. Ultimately, the issue comes down to how much money. But think about it this way. There are parts in Canada's decision letter where it says, in a number of parts, this was an issue that was in discussion at the engagement and negotiation sessions. Does the Crown have to act in the best interest of the Robinson Superior First Nations? Do they have to take the position most favorable to the Robinson Superior First Nations? And Canada determined that no, it doesn't, because it has obligations to others as well.
Well, that's the fiduciary duty question, isn't it?
Yes. But I think what comes out of that is that Canada's decision here is not just a matter of money. It's a matter of what are the implications for the rest of Canada, for all the other Indigenous and non-Indigenous parties in Canada.
What are the implications if a certain dollar amount is spent? It's like, was there some other implication? Like, was there some other impact that was not determined by a dollar amount? Or was there an impact that does not arise from a dollar amount? I'm trying to think, identified in the justification letters?
Mm-hmm. Well, things do, Canada has explained why, for example, it prefers a certain bring forward rate, or why it doesn't subscribe to the theory of economic rents. And it is true that those the ultimate result of those comes down to how much money. So that is true. But I said I'd approach it from both perspectives because I also want to take a look at the Doré case. I don't think it's fair to conclude that the Law Society had no personal interest in how they were going to address or respond to Mr. Doré's letter writing campaign.
Okay.
So where that leads us is, I think it's useful to pick up on Doré because I wanted to talk about some of the problems in the cases that were cited by my friends. One of the cases cited by my friends, Multani, was the Kirpan case. It predated Vavilov, and the standard of review analysis was completely overtaken by Doré. In fact, Doré in 2012 hits Multani head on. Justice Abella states that the approach in Multani was followed. The approach in Multani was consistently criticized in academic commentary. And after Dunsmuir, the Supreme Court moved away from Multani. Multani was balancing the charter right using the Oakes test.
You might tell the reporter how to spell Multani.
Multani.
Thank you.
And the Supreme Court made it clear in Doré that the Oakes test isn't what applies here. There needs to be deference owed to the decision maker who is balancing the charter right with other obligations. So in that way, I sort of do away with the Multani case. It's been overtaken. Now, a more recent case that my friends referred you to was the York Region District School Board versus elementary school teachers, which is a fairly recent decision of the Supreme Court in 2024. This was another situation where the question was, first of all, the question was, is the Charter of Rights and Freedoms even engaged in this situation? And the fact scenario here was a couple of teachers that had been posting things online, and one of them had left their computer on the desk in the school classroom open. The principal came in and saw these comments on this computer, screenshotted them, and disciplined the teachers. And the teachers' union came back and said, "You've violated the charter here." Section 8. And the Supreme Court in York Region says that, and here we can pull up paragraph 63. The majority says here, the correctness standard applies to review the arbitrator's decision. Here they're talking about a labor arbitrator that looked at the issue. I would quash the award because the arbitrator erred in failing to appreciate that a charter right arose from the facts before her. The issue of constitutionality on judicial review of whether a charter right arises, the scope of its protection, and the appropriate framework of analysis is a constitutional question that requires a final and determinate answer from the courts. But what the court is referring to here, this whether a chart arises, that was what is later described as the fatal error that the arbitrator made. We'll move to paragraph 69. In York Region, the arbitrator failed to recognize the teacher's Section 8 charter right applied. I disagree with my colleagues that the standard of reasonableness applies to review the arbitrator's reasons. This appeal can and should be disposed of because of this fatal error. So the fatal error here was that the arbitrator failed to reckon with whether or not the charter right even applied. So the issue here is, when reviewing an administrative decision, a court will apply correctness when deciding whether the charter right applies, and then will apply reasonableness when reviewing the tribunal's balancing of the charter right. That's what Doré told us. York Region does not overturn Doré. And in fact, there have been a couple of cases following along at the lower courts that make that explicit, that York Region does not overturn Doré. There still is to be a balancing of the charter right, and that's done on a reasonableness standard. The only issue on the correctness standard is whether the charter right arises, the scope of its protection and the appropriate framework for analysis. Justice Hennessy, I'm mindful of the fact that my friends from Ontario will also be addressing the standard of review question, and I admit I was impressed by their factum, which was more thorough than mine. And I noted, for example, that they had that helpful chart. So I think, subject to questions that you have about my submissions, I'm going to defer to Ontario to address any other parts of the standard of review that they've dealt with in their factum.
Very good. Thank you.
So now we need to move on to how Canada exercises discretion. Yeah, and I noticed that it's 20 after 11. So I can start with my overview here, or we can take a break.
What's your preference?
I'd be happy to take a break.
Then we will do that. 15 minutes.
Thank you.
This court is stood down for 15 minutes.
All right.
Court is resumed. Please be seated.
You ready?
Thank you, Justice Hennessy. My next topic is to take you through how Canada exercises discretion. I'm going to start with an overview. The difference between the treaty parties, the Crown on the one hand and the First Nations on the other, comes down to three main drivers. And two of those are particularly important as we discuss whether we're looking at net Crown resource revenues, which I'll call NCRR, or a share of rents, economic rents, or a share of economic rents. And the method for bringing the values forward to present value, which we've been referring to as the bring forward rate.
And the third was
Share.
level of share.
The level of sharing, and I'll certainly address that as well. But I would say on share, I don't think there's as much contention that certainly the way that Canada has exercised its discretion looks at a share of between 20 and 50% for the First Nations. And the First Nations have also, as I understand it, in some ways conceded 50% as a possible outcome. So share is something that I will address, but it's not as big a driver of the $30 billion difference as how the benefits are measured, whether it's NCRR or rents or a portion of rents and bring forward rate. So the court in stage 3 and Canada in exercising its discretion had to depend on expert evidence regarding the benefits and the way to assess present value. And just recall, of course, Canada didn't actually collect revenues other than with respect to spectrum, which is an issue. Of course, Canada's position is that they should not be included. Although I will note, for the purpose of this exercise, of exercising its discretion, Canada looked at NCRR values that did include spectrum without making any concession that spectrum was properly included. In any event, Canada had to rely on the plaintiffs and Ontario's experts on the resource revenues. And as we know, the experts came up with different ways of looking at the issues and therefore different calculations. We know that Stiglitz and Hutchings came up with the economic rents approach. Smart and Bodway came up with this approach of investing the proceeds of revenues every year and paying those out in a risk-adjusted manner, paying out risk-adjusted annuities. And,
I'm just trying to figure out your distinction between the two experts' approaches was one rents versus
I'm not distinguishing between
Oh,
approaches. I'm
Those are
just
just two.
demonstrating that there's a range of different ways of looking at the economic issues. The point of my submission, Justice Hennessy, is there is no one answer. There's not even one way of looking at things because each of the experts brought a different approach. The point is that this variety of perspectives demonstrates that the economic issues are not matters of science. No one perspective is gospel. No one perspective is correct. And for that purpose, Justice Hennessy, I was giving you examples about how wildly different these all highly credentialed, well-qualified experts, the different approaches that they all came to and had different perspectives on the same issues. So different, for example, that Smart and Boldway came up with this risk-adjusted annuities approach, which is very different from, now, of course, they calculated net Crown resource revenues, but their approach to share was very unique. And in fact, the parties, and we heard from the First Nations during the engagement sessions, First Nations aren't necessarily all that happy with the concept of a percentage share. And Smart and Boldway, their approach attempted to get away from the percentage share. It was a different approach. I'm not saying Canada adopted that approach because Canada didn't. But my point here is that highly qualified experts can look at this problem from different perspectives and come up with different answers. The whole point being, there is no correct answer. The economists can provide us with some guidance through their different perspectives, but economics is not a matter of science. So Canada considered all of the expert evidence, and just as a judge would do, weighed it, accepted some evidence, made assessments of reliability, and made judgment calls to pick from the various perspectives, the ones that made the most sense.
Is that a contentious statement? Economics is not a matter of science?
I don't think that it is, and I'll get to that. I'm going to show you examples.
Okay.
In fact, the experts themselves say this, they acknowledge it. So Canada examined and considered all of the expert evidence and assessed it and gave certain weight to things that made sense to Canada and not as much weight to things that didn't make sense. That's the same kind of thing I submit, Justice Hennessy, that a judge would do, weighing the evidence, taking the parts that make sense and taking the parts that don't. Canada did this for the purpose of making a settlement offer prior to the stage 3 trial, which you will hear about, and for the purpose of taking a position in its closing submissions at the stage 3 trial. And then took these ideas again into the engagement and negotiation process and modified them as a result of the engagement and negotiation process. But all of this process was a process of considering the various perspectives and adopting those that made sense and not adopting those that didn't make sense.
Made sense to.
I'm going to submit makes sense,
Period.
period.
Okay.
Having in mind that Canada's job here is to provide a rational chain of analysis. And my submission is that by selecting what Canada thought made sense and rejecting what Canada thought didn't make sense, that fits in with Canada's rational chain of analysis. And I'm going to give you examples of that. So I want to start with, just to lead you through the process of how Canada developed its $1.8 billion. And I hope that Your Honor, having already read Canada's decision letter of explanation of January 27, you're probably already familiar with it, but I want to make sure everybody's on the same page. So I want to start with just a reminder about Canada's stage 3 trial position. Because first of all, the January 27th letter of explanation followed on the heels of the December 20 letter of offer. So the parties engaged in these negotiation sessions, there were a lot of questions asked of the Crown, specifically what kind of positions Canada took on specific issues. We'll get into some of that when we discuss the process. But ultimately, Canada wrote a lengthy letter of offer of December 20th, where it explained its position on a lot of these outstanding questions that had arisen during the engagement and negotiation process, and explained its analysis of the 5 factors the Supreme Court enumerated, and came up with an offer. And Canada's offer was based on Canada's assessment of a global amount that Canada felt would be honorable, that Canada determined would be honorable, coupled with Canada's determination that in the circumstances, honorable conduct on the part of Canada required Canada to pay 50% of that. This was not a concession by Canada about the Crown allocation issue, which is something different. As you know, Canada took the position that on Crown allocation, given the facts of the historical facts, Canada, and the fact that Canada didn't collect the revenues, Canada's liability should be less than Ontario's. But for the purpose of exercising its discretion, Canada determined that the honorable conduct would be to pay 50% of its global assessment of $3 billion. So Canada developed its December 20th offer of $3 billion based on, it started with its stage 3 trial position. This is made clear in the December 20th letter. So let's go through the stage 3 trial position. That's right. And Justice Hennessy, you may not recall, but I recall a question that you asked me during Canada's submissions on closing. You said, and I've got the transcript number if you want to look it up. You said, doesn't Canada's approach, isn't it really a negotiation-based kind of approach?
Oh, when you went between.
And I said, well, I impertinently asked a question back and said, is there a problem with that? I went on to explain that
It's good to read transcripts.
it was, Canada deliberately took a compromise position because that is what was required. And it's certainly required in this context now where Canada is being asked to exercise its discretion. If you are interested in looking at that, Justice Hennessy, it's on day 61 of the stage 3 trial at page 11,120, starting at 11,123. So I'd like to go over then again the stage 3 closing position, which I'm going to ask my friend to bring up page 5 of Canada's factum from the stage 3 trial, because it sets out the methodology that Canada used and still uses today and used in its exercise of discretion, the same kind of methodology, which notably is the methodology that the First Nations have suggested, which is you take a share of the benefits brought forward to present value. So just as a reminder, we're looking at paragraph 12 on page 5 of Canada's closing submissions at the stage 3 trial. First, Canada rejected the economic rents approach, and I will briefly go through that later, Justice Hennessy, and remind you why Canada rejected it and why Canada didn't change its mind during the engagement and negotiation sessions.
Can you, there is a question I have, and that is, I think the Crown offers some percentage, 25 or 30% for indirect income.
Ontario does.
Ontario, you don't.
Canada
does not. Thank you.
It's important to note, Justice Hennessy, Canada's and Ontario's methods for arriving at their exercises of discretion were completely different and done. This is evidence, Justice Hennessy, that they were done independently. I'm telling you now, Canada determined its exercise of discretion independently of Ontario. And that is apparent.
Would it surprise you that it's a mystery to an objective reader that two parties dealt with what has been called a very complex body of economic evidence, did their work independently and came up with the same figure?
I do understand that it looks confusing, but I'm telling you, and I will show you, Justice Hennessy, Canada determined Canada made its own independent determination of the amount of compensation that it believed was honorable, that it determined was honorable, and determined the honorable thing for Canada to do would be to pay half of that. How Ontario came to its number is up to Ontario to explain.
Oh, you don't say you were both independent. You say you're only speaking for Canada.
That's correct.
And that what Canada did was independent.
That's correct.
Because,
I can't speak to how Ontario came up with their number.
all right, but I am alerting you to how one might find that a surprising statement. When, as I said, when one is somewhat familiar with that complex body of economic evidence and two parties who say they acted independently come up with the same number on questions on which there is still outstanding debate.
I understand your concern. Justice Hennessy, the honest answer is Canada exercised its discretion independently. And I will show you how Canada exercised its discretion, how Canada made its determination. And I will show you that Canada has always used the same methodology. It's taken into consideration new evidence and new perspectives of the First Nations as they become available, but it's always based on the same methodology, that Canada has used the same methodology. Canada explains in its letter how it came to its determination. It turns out its determination is very different from Ontario's, and Ontario takes positions that Canada does not. For example, this additional 25% for indirect benefits, Canada does not take that position. Canada doesn't find it logical. It's up to Ontario to explain how they came up with their determination.
Not that I am saying that one or another is better or good or not.
Yes, of course. So going back to Canada's position as explained at the stage 3 trial, and I note as well that Canada's position at the closing of the stage 3 trial was consistent with its position at the opening, and eventually we'll get to the opening as well. And that's where Canada, from the outset, we see in the opening statement that Canada filed with the court, Canada said, let's take a look at the revenues. Canada has always rejected the economic rents approach. As I said, I'll get into why. Canada has said, let's take a look at present value. Canada has always rejected the 60-40 approach, and I'll tell you why. Now, as between the Booth and Kersner's tailor-made approach, or the band trust account rate, or the bond rate, Canada has considered all three of them. It said that it would, and it did consider all three of them in its stage 3 position and in its exercise of discretion.
Sorry, considered all three. Can you give me those again? Booth and Kurtz.
Booth and Kersner,
Yeah.
band trust account rate, or bond rate. And frankly, three of them are related. They're all different ways of looking at, all reasonable, I will say, reasonable ways of looking at present value. There's certainly criticisms of some over the other that I will acknowledge, but generally they're in the same ballpark. They're different conceptually from the 60-40 portfolio approach, which Canada has consistently rejected for reasons I'll get into. So Canada takes net Crown resource revenues brought forward at a rate other than the 60-40 rate. And then the share for the First Nations, even from the outset of the commencement of the trial, in its opening statement, Canada noted that, well, based on the expert evidence of Mintz and O'Riordan, well, one perspective would be a share of the population, which would be 10%. Another perspective would be 50-50 is another reasonable perspective. So Canada's always taken the position. Now, in the opening, it was between 10% and 50%. By the time of the closing, Canada conceded maybe 20% to 50%. Canada made that move up, acknowledging Mintz and O'Riordan's evidence that a purely population-based approach would probably not address the difference in needs of the First Nations compared with the rest of the population. So that's why Canada came up to 20 to 50%.
And it was Mince and O'Riordan who were at population base?
Yes, that's correct. They used that example of Czechoslovakia. They said when the Czechoslovakia broke up into the Czech and Slovak republics, they distributed assets based on population. And they said one of the problems with the population-based approach is it may come up with arbitrary results when the populations are vastly different. I just mention that as to jog your memory about that evidence. But yeah, the population approach was one way to look at it, and I will show you, Justice Hennessy, how Canada approaches that population-based approach. You know, again, not as gospel. It's not science. It's not gospel. It is a balancing of perspectives. So going back to stage 3, Canada said at that point, the evidence between Hutchings and Smart and Boldway was a range of 8.9 billion for NCRR on the Hutchings side and minus 4.6 billion for Smart and Boldway. Now, Canada was transparent in its stage 3 closing submissions and in its December 20 letter of offer that one of the reasons Canada picked these figures to compare is because they were the only figures that were comparable because they were both brought forward at the bond rate. In fact, I think I'll ask my colleague, Ms. McNamara, to go back to the previous page. Am I right? Or was it paragraph 23? Where
Could I ask if it's in the compendium, could you direct me to that as well, please? Only those documents that are in the compendium.
yes, and Justice Hennessy, I'm sorry to say, this is not in the compendium because it's in our factum. It's hyperlinked to our factum. So I can give you the footnote references where this is hyperlinked.
Thank you.
So this is hyperlinked to our factum footnote 104 and footnote 106.
Thank you.
So, so my colleague has brought up other parts of this part of Canada's factum, which, as I said, you'll also find parts of Canada's closing submission factum at footnote, as I said, 104, also 105, 106, and 110. That is where you'll be able to access the factum excerpts that my colleague is putting on the board. So we note in the closing factum, the available data allows a direct comparison between the Hutchings-Stiglitz NCRR estimate and the Smart-Boldway NCR estimate when expressed in present value using the government bond rate. This is the only rate at which Smart-Boldway calculated the present value of their estimated NCRR. And actually in those submissions, Justice Hennessy, we included a chart to show where you could compare numbers because some of them, had been brought forward at the band trust account rate, others only at the bond rate. And I know, Justice Hennessy, you noted yourself, like it doesn't really help you when you don't have a mathematician or an economist to do the calculations for you. We have to work with the evidence we have. And Canada worked with the evidence it had. The only comparable, there's the chart, thank you. The only point of comparison could be between those figures brought forward at the government bond rate. So going back then to Canada's explanation, my colleague had on the board paragraphs 10 and 11. So Canada explains that the government bond rate, which averaged 5% over the time period, is reasonable to consider for the assessment of compensation for the past in this case. It represents roughly the midpoint between the average band trust account rate, which was 5.3%, and the average rate of 4.5% that was estimated by Booth and Kersner. So Canada is saying here, we're taking a bit of this and a bit of that. The bond rate is a reasonable rate when you consider it's roughly in between, slightly higher than the mix between the Booth-Kersner rate and the BTA rate. And Canada goes on to explain, well, the BTA rate has been the same as the government bond rate since 1969. It is a relevant benchmark, which all of the experts used in at least some of their calculations. Furthermore, the tailor-made Booth-Kersner approach is realistic and responsive to the facts, consistent with the case law, and that was the Whitefish case of the Ontario Court of Appeal in 2007, and should be incorporated into analysis of present value. So,
Can you just remind me, the page that is on the screen is from,
Canada's closing submissions
yes,
of the factum,
yes,
page 4.
thank you.
You can access that at footnote 105 of our factum.
Ah, thank you.
This is described in our factum and noted in paragraph 4, page 4, paragraph 11, footnote 105 of our factum. So then we can move on to the next paragraph, paragraph 11, which is on page 5. And this again, you can access through footnote 104.
I just want to make some notes in your factum, if I may.
And Justice Hennessy, I do apologize that I wish I did have my materials a bit better organized in terms of putting these into a compendium. Part of the problem was being out of town the last week. So I wasn't able to get my materials together as nicely as I would have liked. Everything is available to you, but not necessarily in the easiest way.
Well, all I will continue to ask is that you identify as best you can the different places where it is. Thank you.
Okay. Are you ready to?
Yes.
Yeah. So now we're looking at page 5, paragraph 12 of Canada's closing submissions at the stage 3 trial. And you may recall this, Canada took the figures of 8.9 billion and minus 4.6 billion and said, well, the range, what is the appropriate, what is a reasonable figure for Canada to base its determination on? It's not going to accept everything that Hutchings said because Smart and Bodway had some valid criticisms. And it's not going to accept everything that Smart and Bodway said because Hutchings had some very, very valid criticisms of Smart and Bodway. So Canada took a position, well, the midpoint between those two is 2.16 billion. But then Canada conceded that Hutchings' evidence was stronger than Smart and Bodway's on this issue of net crown resource revenues. Smart and Bodway probably were over-inclusive in their expenses. And in fact, that turns out to have been later admitted by Smart and Bodway. We'll get to that. So Canada determined, well, maybe the better approach then, as opposed to saying the present value of net crown resource revenues is 2.16 billion, Canada says, well, a figure that separates the distance between the two extremes into thirds and is 2/3 closer to Hutchings is 4.4. If it's 3/4 closer to Hutchings, we're taking a 3/4 approach, it's 5.5, 5.53. And another, if we just assume that NCRR could never go below 0, if we put Smart and Bodway at 0 rather than minus 4.6, then the midpoint would be 4.45. And Canada said, here's a range, throw out the 2.16. It's at one extreme. Canada's not just taking the midway point between the two. Canada's taking a point that is more heavily weighted to the plaintiff's expert Hutchings and says between 4.4, 4.45, 5.3, Canada is going to say it's in the range of 4.4 to 5.5. Then Canada goes on to say the share for the First Nations should be between 20% and 50%. And now at the stage 3 trial, Canada's position was Canada's liability should be a maximum of 20%. So you'll see on the next page, so it's, it would actually be page 8, paragraph 23. In conclusion,
Page 8 of your closing.
that's right. Page 8 of the closing, paragraph 23, is sort of the summary of where Canada lands on this. On this basis, the award of compensation for the failure to augment the annuities pursuant to the augmentation promise in the treaty should be at a range of 578 million to 2.45 billion. And well, you know, Canada had said, well, its share should only be 20% of that. Canada came up to a lower figure for its own liability, but Canada did note and did take the position at the stage 3 closing that a reasonable compensation for past annuity augmentations would be 2.45 billion. And that was based on the high end of Canada's assessment, not the 4.4, but the 5.5 billion, right? 50% being the First Nations share. Because again, we're looking at the high end. The highest end would be take the most favorable NCRR for the First Nations, 5.5 billion, take the most favorable share for the First Nations, 50%, and then you subtract the 302 million already paid, and that's where we get the 2.45.
So the 5.5 was the highest assessment of NCRRs.
That's right, and it was based on a figure that was 3/4 of the way towards Hutchings. It was a mix between Hutchings and Smart and Bodway, but heavily weighted towards Hutchings.
All right. Take 50% of that as
50% as the share for the First Nations. And this again was on the evidence of, well, Canada's position was all of the experts gave testimony that 50% has grounding in bargaining theory. Now,
that comes to 2.45.
2.45.
Oh, no,
And-
less 300.
Yeah, it comes actually to 2.75. If you take 5.5 and split it in half, you come up with 2.75. And then you subtract 302 in annuities already, 302 million in annuities already paid. That's how Canada came up with 2.45 billion dollars. Now, I'll get to it again later because I am going to explain, as I said I would, why Canada rejects economic rents and why Canada rejects the 60/40 portfolio rate. I'm also going to get into a bit more detail about share, but let me just remind you, Justice Hennessy, that Canada's position on share has always been somewhere between 20 and 50%. And part of that is going to be dependent on what we're sharing. And so here, the high end analysis would give us a result of 2.45 billion. But this isn't actually a concession on the part of Canada that 50% share is the right share for the First Nations, because Canada also suggested it could be a 20% share. This is where we provided the range. Now, happily, we can move off of Canada's closing submissions at the stage 3 trial and move to something that is actually in the record. And that is Canada's December 20th letter, which is at tab 46 of the record.
Go ahead.
Canada, this letter is slightly altered from the way that it was delivered to the First Nations because we increased the size, the spacing to double spacing for the purpose of this record.
Thank you.
So the letter goes through, as I mentioned earlier, Canada's responses to the First Nations on a number of issues that.
Sorry, are we at the December letter?
Yes, we are.
Thank you.
Tab 46.
Thank you.
Starts on page 2,970 of the record. And just a bit of background about this letter. It During the engagement and negotiation sessions, there were a lot of questions asked by the First Nations, particularly in the form of letters from their council, many letters from their council with many questions, and you will see those in the record. And when we go through the process, I will explain why Canada was not always, and in fact usually wasn't, able to answer these questions on the spot. Canada had to say, we'll consider and get back to you. So the December 20 letter represents Canada getting back to the First Nations on a number of issues that were raised by council in the correspondence during the negotiation process. So the December 20 letter deals with that, answers questions. It also explains Canada's approach to the 5 factors that were enumerated by the Supreme Court, goes through each one of those factors and how Canada considered them. And then it goes through an analysis of how, this rational chain of analysis of how Canada arrives at a figure to offer. And the offer was Canada had assessed the global amount of compensation based on Canada's assessment of the 5 factors at $3 billion. And as I noted, Canada took the position that the honorable thing to do would be to pay 50% of that. Without conceding any issues on Crown allocation, it would pay 50% of that. So what I want to take you through is, my colleague has it up on the screen. It is page 3016 of the record. And here's where, in this December 20th letter, Canada goes through, again, not one approach about this is how Canada sees it, but Canada is weighing the different evidence and looking at different perspectives and determining an amount that is going to be honorable from a variety of perspectives. Canada's approach was, economics isn't science. We've got problems with what Hutchings says. We've got problems with what Smart and Bodway say. We got problems. We know we've got problems with what Booth and Kersner say, because, you know, the other parties had valid criticisms of their approach. So we've got a lot of problems. So what are we going to do? We're going to just take different approaches of looking at the issues that seem to make sense. And what Canada does is start with different scenarios. Scenario 1 is, well, Canada honestly believed at its stage 3 closing that it took an honorable approach. And so Canada starts with the stage 3, the high end of the stage 3 position, $2.45 billion, is an honorable approach. It is, it's rational because it's based on this methodology of a certain share of net crown resource revenues, like having in consideration the fact that Hutchings did better than Smart and Bodway on NCRRs, takes into consideration various different bring forward rates other than the 60-40, takes into consideration the 20%, 50% share. And so Canada stands by its determination that 2.45 billion was an honorable approach. As I said, it was rationally explained and connected to the facts and the law, which when we went through standard of review, we talked about that's how you measure reasonableness, and that's effectively honorableness in this case. So Canada believed that that approach was honorable, but said, okay, now we've been through the negotiation and engagement process, we should be updating those figures. So scenario 1 in the December offer was updating the stage 3 figures using the exact same analysis where we ended up at 2.45 billion and increase that based on updating to cover revenues from 2020 to 2024. Because the experts' evidence at the stage 3 trial was, here are the revenues that go up to 2019. We don't have evidence yet for the next 5 years, 2020, 1, 2, 3, and 4. And Canada had in mind a couple of things. One, the Supreme Court explicitly told Canada and Ontario, the Crown, that they were to pay an amount to compensate for breach of the treaty from 1875 to the present. Now, one of the concessions Canada made was not to go to 1875, but actually to go back to 1850. That's an honorable concession that Canada made. So we were looking at a figure for 1850 to the present being effectively December 31st, 2024. So how is Canada supposed to be accounting for these last 5 years when it doesn't have any evidence? Canada determined, Smart and Boldway say there are no revenues, but Hutchings says that in the previous 5 years, 2014 to 2019, Hutchings had provided the amounts of net Crown resource revenues under his analysis, and Canada said, we will take that at face value without discounting it at all for, comparing what Smart and Boldway said about actually the figure zero. We're just going to take it at face value to be honorable. We'll take at face value what Hutchings said about the last 5 years, and we will average those and estimate that, well, the estimate, it turns out to be 120 million is the estimate that Canada came up with. Now, this is explained in that December 20th letter at page 3019.
Can you tell me the page number of the letter, or is that?
50
Got it, thank
of
you.
the double space page letter, yeah. 50 to 51.
Thank you.
This is where Canada explains, and I was intending to address this later, and I may have to come back to it, but let me just jump in now to say, when my friend said that Canada arbitrarily came up with a figure for the future, it's not arbitrary. It's clearly explained how Canada did it. Canada took the Hutchings numbers for the previous 5 years at face value, found the annual average, and calculated that for the next 5 years. And then, so that figure was 120 million. And then Canada said, well, 50% share for the First Nations would be 60 million. So the conclusion that Canada made on scenario 1 in its offer was the 2.45 plus 60 million. And that gets us to 2.51 billion. Now, in the December 20th letter, scenario 1, Canada maintained this view that one way to look at it would be Canada liable for 20%. And that's why you'll see on page 52 of the letter, or 3021 of the record, Canada's conclusion of, I'm just waiting for my colleague to catch up. It's page 52, 3000. Yeah, there it is. So Canada then said, well, if Canada is liable for 20% and Ontario is liable for 80%, here's Canada's share, 502 million. Plus interest, because Canada's acknowledging that all these calculations were done on the basis of figures that only went up to 2019. So we also have to calculate interest. But I'm going to ask you, Justice Hennessy, like, scenario 1 is really the same as scenario 2, because scenario 1 was a 20% share for Canada. Canada has since acknowledged the honorable thing to do is to pay a 50% share as between Canada and Ontario.
I do have a question on that. How honorable was it on December 20th to still be talking about 20%? Not that it was a number, but that you were saying to the First Nations, by the way, we don't have any agreement with Ontario, and we are going to play this out, plaintiffs, so that you get to, as they said from the beginning of stage 1, they get to be an audience at this dispute between Canada and Ontario. And it's now December 2024, month 5 in an engagement process. I sound possibly frustrated with that.
Yes, and I understand. And Justice Hennessy, this scenario is played out to demonstrate how Canada's exercise of discretion and how Canada's offer came out of the same position Canada took at the stage 3 trial. It's not, Canada absolutely does not adopt the 20% here.
But
It doesn't factor
what are
in.
the First Nations to think about that process?
The First Nations are well aware that Crown allocation is an issue that has already been argued, and with 3 different experts giving evidence, and that this is an issue that is going to be determined, or if not by the court, then by Canada and Ontario. It is going to be resolved. It's certainly in Canada's letter of December 20 and its January 27th letter. Canada does take the position that the honorable thing to do is to pay 50%. So the fact that we use the scenario 1 in order to show the evolution of the thinking, that's all it is. It's not that Canada is at all taking the position that 20% is the honorable share to pay the First Nations. This is why I say, you know, scenario 1 is there to show the evolution really, and so that you can link up the numbers. But in reality, scenario 2 is reconsidering stage 3 position with reference to the Supreme Court's decision. And that's where Canada says, you know, the honorable thing to do here, despite our dispute with Ontario. And I'll say, Justice Hennessy, you know, Canada fought that issue of Crown allocation because Canada does believe it has very good arguments on the law and the facts that Ontario should really be bearing the brunt of this past compensation because they're the ones that collected the revenues. And remember that Section 109 of the Constitution Act says they took the land subject to any interest of others. And Canada says the interest of others was the interest of the First Nations. So Canada had good legal, I submit good legal and factual arguments on the Crown allocation issue. And Canada does believe that the honorable thing to do vis-a-vis the First Nations is to pay 50%. Canada doesn't make that concession lightly. And as I said, doesn't make the concession that that's actually the right result as between Canada and Ontario. But Canada's trying to take the approach that we've heard the First Nations, they don't want to be involved in this dispute. Therefore, for the purpose of this exercise of discretion, we'll just pay 50%. Now, there is no, part of the problem, you may remember, that was argued before you on this Crown allocation, there is no clear path for Canada to turn around and collect whatever it pays from Ontario. There's no clear legal path for that. This isn't a situation of joint tortfeasors governed by the Negligence Act. So it's not like Canada could just say, well, we'll pay the whole thing and go and collect it from Ontario. There's no legal certainty that Canada would be able to do that. And so Canada did feel that the honorable thing to do was pay 50%. Anyway, we can go through the second scenario very quickly because it's basically the same, except that Canada acknowledges now the honorable thing to do is pay 50% of it, but it's still the same figure, which is 2.51 billion. And that was based, again, just to recap, on the 2.45 that we went through from the stage 3 trial, plus 60 million to account for 2020 to 2020, end of 2024. So we're now at a figure of 2.51 billion. And again, Canada notes that interest would have to be added to that. And Canada attempts, this was before we had figures from Mr. Hutchings. Remember, Mr. Hutchings' interest calculations are at tab 55 of the record, which, and this is at tab 46 of the record, which is chronological. So you can see that Canada's position here was developed before it received those interest calculations from Mr. Hutchings. So Canada used, and it's on page 59 of the letter, record 3028. And this point isn't really relevant. The numbers aren't particularly relevant, Justice Hennessy, but the point I'm making here is Canada did have interest in mind and did its own calculation based on the band trust account and came up with its share, which would be 1.373. I had written down what that is. If that would be 1/2 of 2.75. So again.
I've missed that last.
Yeah, okay, so what I'm looking at is is page 3028. And we end up with, so it would be, the highlighted part would be 2.51 billion. Canada's 50% share would bring it to 1.255 billion. But Canada noted, well, you'd have to add interest
To
to the
2024.
That's right, yeah. So exactly how Canada calculated the potential interest, I don't think we need to get into, but the point is that Canada acknowledged that these figures don't account for interest in the last 4 years. Okay, so, but anyway, we're still in a range of, we've now moved from the stage 3 trial being 2.45 billion. We've now moved to 2.51 billion plus interest. And then Canada considers a new way of looking at things as a result of the negotiation and engagement sessions and calls this scenario 3, alternative approach. That starts on page 60 of the letter, page 3029 of the record. I'm looking at the time, Justice Hennessy. This might be a good place to stop if people are getting tired. But if you'd like me to plow ahead, I can plow ahead. I'm sorry?
Or hypoglycemic. Just one thing. I think if you think it's a good place to stop, we'll do that. Can you tell me how you are seeing your time? Are you on track for your estimates?
Yeah, I am on track. We're looking at item number 2. I'm finished A, B, and C. I hope to finish D to I by the end of the day.
But that's within your estimate?
Yep.
Okay. Let's do it. Let's take the break then.
Thank you. And reconvene
Till
at
2.
2. Thank you.
Thank you all. Till 2.
Alderman Rice.
This court is to down till 2 p.m.